Good afternoon. I'm delighted to be here with my colleague, Richard Blumenthal, who, as you all know, served for some period of time as the Attorney General of the state of Connecticut, and who has argued, I think, 4 cases before the Supreme Court. And I am a member of the court, though I have not argued a case, but have worked in this field. I sat in the court yesterday, as I did for Bush v. Gore, and I listened very, very carefully to the arguments, as everybody did, because this is obviously one of the most important cases of our lifetime. In 30 cases challenging the Affordable Care Act, the courts have either upheld the law or dismissed the case on procedural grounds. 3 Court of Appeals panels said the Affordable Care Act is constitutional. Now, I am glad, as I think any of us who practice law are, to see the intense questions from the justices. They're engaged and they are thoughtfully working through these issues. But questions are a legitimate way of probing the basis of their own thinking. They are not an indication of a judgment made or a vote ready to be cast. They're working through this process, as they ought to, mindful of the fact that those 30 courts below them have already made a judgment upholding it. Now, while we're talking about the fine points of constitutional law, I think it's important, and we think it's important, for all of us to remember that for millions of Americans, this boils down to something pretty basic, and that is access to affordable health care. It wasn't easy to get here. Been here for 26 years, working with Senator Kennedy and others to help get us down the road in this journey. And it's critical for everyone to remember that the individual mandate was originally a Republican idea. They invented it. In fact, back when the Republicans were trying to kill what they derisively called Hillary Care, Newt Gingrich, Bob Dole, and others were promoting an individual mandate. Republicans didn't have any issue with constitutionality when it was included in legislation by Senator John Chafee and Congressman Bill Thomas, both Republicans. And eventually, the individual mandate was adopted by a Republican governor in my state and passed into law. As a senior member of the Finance Committee, I can tell you that we had one of the most rigorous and transparent legislative processes that I have witnessed in almost 3 decades here in the Congress. We worked with some of the brightest, most thoughtful, and experienced constitutional lawyers in order to make sure that the law was constitutional. Judge Jeffrey Sutton, who ruled in favor of the mandate in the 6th Circuit and was a former clerk to Justice Scalia, said, and I quote, "No matter how you slice the relevant market, as obtaining health care or paying for health care or insuring for health care, all of these activities affect interstate commerce in a substantial way." That's a former clerk to Justice Scalia. Now, frankly, Justice Breyer yesterday, I think, summed it up pretty succinctly. He looked to the history books and he looked to the case of McCulloch v. Maryland, where a national bank was established, and he stated, "I look back into history and I see it seems pretty clear that if there are substantial effects on commerce, interstate commerce, Congress can act." Now, Congress's power to regulate interstate commerce is certainly broad enough to encompass the way the law was written. The Supreme Court has interpreted this power to mean that if Congress can pass the law, if the economic activity being regulated, taken in the aggregate, has a substantial effect on interstate commerce, it's permissible. I think most people, especially those paying the bill, the countless Americans who pay the bill for the people who don't get insurance, they understand how it affects interstate commerce because it affects them and their pocketbook. We're talking about more than $2 trillion a year, one of every $6 in our economy. So it isn't about eating broccoli, folks. There's no other economic commodity in the entire marketplace like healthcare. Like it or not, at some point in our lives, every single person will receive healthcare. And every single person is constantly at risk on any given day of requiring emergency services and health care services. Individuals don't determine when they need the health care. And when they need it, it may well not be feasible for them to be able to make a decision about then paying for it. In other words, you can't wait till you're in the back of an ambulance to make the decision, gee, now I want health care. Those who forego health insurance don't opt out of the health care market. You know what they do? They opt to send the bill to everybody else who pays it. So this cost shifts over $1,000 to the average price of family insurance. And ladies and gentlemen, that has a profound impact on interstate commerce. So, you know, the case is so important because the other insurance market reforms that we've passed only work if you have all of the system working as a whole. If you don't require people to have health insurance, then some of them will hold off buying insurance. Then the system doesn't have the money to pay for the people who have it. The prices go up, and the entire system is impacted. When we started to work on this bill, 1/6 of our population did not have any health care coverage. That's 45 million Americans. And among those, about 45,000 died every single year because they didn't have insurance. They couldn't afford it, or they were denied it because of a pre-existing condition. More than 60% of the personal bankruptcies were caused by medical costs overwhelming family budgets. And all of those skyrocketing costs put so many businesses at a disadvantage against competitors in other countries. All of those things I just listed are an impact on interstate commerce, and they come about as the result of people not covering themselves. So I am confident that the Affordable Health Care Act, as people begin to see all of its workings and how it's interconnected, and as people see how critical it is, they will decide they don't want to go back to a nation where you get cancer and you get a letter from your insurance company and you're told you're no longer covered. Where people who are women who are pregnant are told, gee, you have a pre-existing condition, you can't get coverage. That's what's at stake in this struggle. And I am confident that the prior precedents of the court, providing the court doesn't reach, doesn't stretch, doesn't go outside of that precedent, that this court can uphold this law.